We're right at 11 o'clock on time, so the next case is Burlington Coat Factory versus Marva, or Lloyd versus Burlington Coat Factory, I want to say. Are both sides here? Come on up. Each side is going to have 15 minutes to present their arguments. Ms. Lloyd, since you are the appellant and you have filed this appeal, you will have 15 minutes as well, but you may elect, if you so choose, to have 5 minutes, up to 5 minutes for rebuttal, so that when she argues, then you can get up and rebut what she says. Would you like to save some time for that?
Yes,
Okay.
if necessary. So would I take 10 minutes to argue and 5 to rebut?
That's up to you. You can sit, you can argue for 13 minutes and take 2 or whatever, but
Okay.
you ready? 10 and 5?
Or 10 and whatever's, whatever's necessary.
Okay, all right, that's fine. I'll just tell you as you're getting into the last 5.
It won't be that long.
Okay. Come up here if you don't care and stand in front of the microphone. We're videotaping and so, so we'll have a view of you and then we can all see you clearly too. Okay, you may start.
Yeah, as the court is aware, I'm not an attorney. And so I really came here just to, I didn't request for argument, opposing counsel did, but I came to clarify anything and answer any questions for the record, but to simply make a brief statement and point out some things that I outlined in my briefs. And I just wanted to read this. I'm not arguing. Yeah, I just wanted to read it. Good morning, Your Honors. May it please the court. My name is Marva Lloyd. I'm the plaintiff pro se in this matter. And Your Honors, this is 6 paragraphs. It's not. I'm not going to spend 10 minutes reading.
That's right. You go ahead.
Okay. I begin this morning by stating the obvious. I'm not an attorney. However, a license to practice law is not a prerequisite to come to court and tell the truth. Your Honors, this is not my arena. It's not what I do, nor did I want to represent myself in this case. I was forced through circumstance to proceed pro se because I lacked the financial resources to retain counsel. Pursuing litigation with limited legal knowledge is not easy, but that burden is compounded when the law is not being equally applied, as evidenced by my experience in the lower court. It is my prayer that I will be granted the privilege of being heard today, as that privilege was denied below. I understand my role today is not to retry this case, but to present issues raised on appeal in an effort to facilitate your review and determining whether the law was fairly and equally applied and correctly applied. I stand before you arguing that it was not. I'm here today urging the court to reverse the judgment of the lower court, which resulted in a directed verdict entered against me in the case in November of 2016, as the record evidence does not support the lower court's judgment, but on the contrary, weighs heavily against it. Not only does the judgment lack sufficient evidence, but the record provides overwhelming evidence of egregious misconduct by opposing counsel, Stephen Krimmer, who not only engaged in a years-long multi-step process to deceive the court, but went unrestrained in his efforts to thwart the judicial process. Your Honors, Lady Justice is not blinded by emotions nor personal feelings toward the parties. Her blindfold is there purposely to objectively and fairly weigh the evidence. That did not happen in this case. Although there were errors that occurred during the trial, there's no necessity for this court to reach the merits of those errors, because what transpired during the pretrial is sufficiently egregious to warrant a reversal. Aside from the 4 assignments of errors raised on appeal, the decision of the trial court should not only be reversed, but I urge this court to enter judgment in plaintiff's favor on all claims due to the serious nature of the violations committed by opposing counsel. Counsel's myriad professional conduct rule 8.4c violations, a rule that prohibits lawyers from being deceitful, dishonest, and making misrepresentations, all of which counsel has done, and the gravity of such conduct warrants nothing less than a death penalty sanction and reversal of judgment on all claims. I'd like to start by, and I'm going to address these these out of order, just to facilitate review. The issues that, the first assignment of error that I raised was that counsel's frivolous conduct in disputing the purchase for over 2 years was prejudicial to the administration of justice. This case was a bed bug case about me purchasing a comforter set from Burlington Co-Factory on February 11, 2012. It took some time for me, after ruling out several things, scarlet fever that was reported at my daughter's daycare and some other issues, food allergies, a new detergent, and all other things before I actually discovered the culprit, which were the bed bugs that I found in the comforter on March 30th, 2012. On March 31st, 2012, I contacted the store on March 30th, 2012, and spoke with the manager. On March 31st, 2012, I went to the defendant's place of business. I was urged not to bring the comforter back because I didn't have a purchase receipt. I used a layaway receipt that I had placed the same day of the purchase to assist the manager with locating the purchase. I took the barcode cards in stock to the store with a plastic bag so that they could scan it to also locate the purchase, which they did. I had mistakenly concluded that I had used my debit card. My sister was with me on both occasions, and we both used my debit card that day, but I was at register 6 at the layaway register, she was at register 4. She used my card first at register 4, and I made 3 sequential purchases at register number 6 at the layaway register. After refunding me for the purchase of the comforter and the canceled layaway, which they deducted $10 after they canceled my layaway, after I canceled the layaway, they deducted the $10 from the deposit. They gave me a full refund plus tax. Because my home had become infested with bed bugs, I simply contacted the defendants and asked them, not for money, I asked them could they replace my bed, could they replace my carpeting, or have it professionally cleaned. That's all I asked for. I gave them an estimate of less than $2,000. That was less than one of my paychecks. The defendants asked me to provide some information regarding the receipts and purchases. I explained the situation, I didn't have it, but I explained that they had issued a full refund. But from that point forward, they never, ever responded. In 2013, because I thought that there was a statute of limitations of 1 year, I sent a letter, 2 letters actually, on March 13, 2013, March 17, 2013. I mailed one, and I faxed the other to their general counsel, Mr. Paul Tang, advising of my intent to take legal action because myself and my daughter had been bitten. My daughter, Your Honors, minimally 3,000 times. 3,000 times. That's not a number that I'm snatching out of the air. My daughter was bitten anywhere between 30 and 45 times a day. 15 bites here, 10 bites here, 17 here, 15 here, all over the place, over an 11-month period, to where I had to abandon that property in the dead of winter, and I just left it and had to move. I didn't have great credit history, so I had to take the first thing that someone would offer me. After I mailed the letter, I gave them a deadline of time to respond by 7 days. And because I had mailed it and was going to allow them time, I said, well, maybe if they don't get it within the next few days, I'll go ahead and fax this and give them to the 22nd, March 22nd. They had their insurance adjuster contact me on March 20th. She asked if she could take a recorded statement from me. She took it on March 21st, 2013. I provided her all of the information pertaining to the purchase and the refund. In April of 2013, she sent me a letter advising that they were not liable, period. She provided no basis other than that they were just not liable. When I started doing some research, I found that Burlington had a problem with the bed bug infestation. It was reported that they had a bed bug infestation throughout their distribution chain. When I found that out, I contacted the corporate office again. I received no response. And when I found out from an associate of my sister's doing some political campaign, I went to pick my sister up. She came up and told me, because she's a paralegal, and I told her about it. I contacted Professor Devaney, who was one of my professors at App.No, and asked him what should I do about it. And he told me to try to get it figured out with the local managers here. I told them they had refunded me, but because of the infestation, I didn't know what else I could do. I didn't know what other recourse. But after finding out that they had this issue, I felt that they were aware that they had this issue. I filed a complaint on March 27, 2014 for damages. From March 27, 2014 until September 30th, 2010, September 27, 2016, counsel for the defendant, Stephen Krimmer, frivolously disputed the purchase, advising that I never purchased this comforter from Burlington. After being refunded for the purchase, after having receipts for the refunds, he disputed the purchase for 2.5 years of the litigation. There was no basis in law whatsoever for him to dispute that purchase, because the purchase was verified by their system on March 31st, 2012, pursuant to the defendant's own refund policy, that non-received returns would be subject to system verification and manager approval. And that is exactly what happened that day. That is one of many arguments with respect to the frivolous conduct. Mr. Krimmer was very evasive in my discovery request. He advised that no record existed of the purchase. I suspected spoliation, but Your Honors, he committed a grave error. When he submitted those admissions advising that there was no record of purchase, he forgot about the refund. Because when you receive a refund from Burlington Coat Factory, especially for a layaway, they give you refund receipts, and he forgot about those. So when he advised Judge Teodosio on August 5th, 2015, that she went there with a plastic bag containing a barcode, which was a fact, he advised that no one had any recollection of what transpired. But on August 20th, 2015, I found the refund receipts in my storage. I contacted Mr. Krimmer via email, and I sent him a letter on September 8th advising him of that fact. But prior to doing that, Mr. Krimmer had submitted a response to my motion for summary judgment on September the 4th, advising that they were disputing the purchase and that I had not produced any proof. But when I sent that to him on September the 8th, I replied to his opposition on September 14th, and I included all the transaction information. Because the defendants were disputing the purchase, I did not feel comfortable giving them the original receipts. So when I tried to make copies of it, because they were drastically illegible, I simply could not photocopy them. So I took all the transaction information and provided all the information with respect to the layaway purchase, with respect to the comforter's purchase, and with respect to the purchase that my sister used at a different register. So,
I'm sorry, no. I was letting you go past the 5 minutes.
Oh.
My colleague reminded me that if you want to save some time, it's over 3 minutes.
Okay.
Do you want to still go?
Yeah, I do want to go. I just wanted to, so there was, just in wrapping that up with respect to the frivolous conduct, Mr. Krimmer not only disputed the purchase, but because he kept doing that, I had to find a way to secure the receipts from their corporate office or from them. So I used an unknown email address. And I contacted the corporate office in the event that they had flagged my email and rerouted it somewhere. I was able to secure those receipts. And to test my theory, I followed up with that using my regular email and requesting the receipts. They advised that there was no record of the purchase 30 days after the purchase. That is all I'm going to say with respect to the frivolous conduct. My assignment of error number 2, Lloyd argues that the trial court failed to resolve discovery conflicts, pointing to opposing affidavits submitted by both parties. Both Mr. Krimmer and myself submitted affidavits advising that I advised the purchase. I averred that the purchase occurred on February 11, 2012. He averred that the purchase occurred on February 23, 2012. I used my credit card that day, Your Honor. There's nowhere in my bank statements other than February 11th where I used my credit card. That information was provided to him, and he still disputed that.
Ms. Lloyd, you only have 2 minutes left, and I want to ask you a real quick question.
Okay.
When the actual trial, there was a trial, right?
Yes.
And the jury was impaneled and so forth.
Yes.
The judge said in his order that you refused to submit any evidence.
because Judge Kimbler, after impaneling the jury, advised me that I was engaged in the unauthorized practice of law by presenting photos of my daughter. And he advised that he would not permit me to offer photos of my daughter's bites, which were central to my claims of emotional distress, nor would he allow me to mention the fact that I took my daughter to the doctor to rule out any other possibilities, which were central to me establishing my statute of limitations. He advised that, he claimed that that would be the unauthorized practice of law. I disagree with that, Your Honor, because my understanding of the unauthorized practice of law did not fit with what Judge Kimbler said. He recessed court and stated that we could come back tomorrow, briefing him on cases where courts permit parents to argue on behalf of their children. Well, I did do that with regard to special education and children with special needs in their education, because that's what he asked for. But I also...
Ms. Lloyd, I just want to say, you're only at 40 seconds.
Okay.
You want to say that?
No, I'm just going to stay for the record and just let it go. But I also wanted to state that because he had done that, and because he had done a couple of things, he even acknowledged that he should have told me that before he impaneled the jury. But because he did that, I challenged the jurisdiction of the court, because I found in my research that by challenging the jurisdiction of the court, he would have to stop the proceedings. Judge Kimbler decided that he was going to overstep his authority and proceed with the proceedings anyway, and he ordered me to proceed with the case, and I refused to do it. I made a statement with respect to the jury advising them that I would not, and my reasons for that, and I rested.
Thank you. You may proceed.
Good morning. May it please the court, my name is Lloyd, here today on behalf of the defendant, Burlington Factory, arguing in favor of the trial court's dismissal below. There are two issues before this court on appeal. The first one is, did the trial court abuse its discretion by failing to grant plaintiff's request for sanctions? The second issue before the court is, was the trial court's grant of directed verdict at trial in error? Respectfully, the answer to both of those questions is no. There were two motions accusing defense counsel of misconduct below. The first one occurred on October 6, 2016. It was captioned Notice of Attorney Misconduct Motion to Stay. The motion itself does not request any sanctions. Instead, what plaintiff asks for was more time so that she could seek evidence for a motion to file at a later date. That later date happened on October 31st, 2017, when plaintiff's second motion was filed. This one accused defense counsel of falsifying evidence, falsifying an affidavit, spoliation of evidence, abuse of the legal system, and fraud upon the court. The entire dispute had to do with when plaintiff purchased the comforter. Was it February 11th or February 23rd? Burlington was under the assumption, based upon its own records, that that date was February 23rd. Plaintiff, after several, year and a half, maybe even close to 2 years, produced evidence that it was actually occurred on February 11th.
So you're saying you never disputed that she bought the comforter then?
What was disputed that she bought a used comforter that was infested with bed bugs. No one ever disputed that she made a purchase at Burlington Coat Factory that day. Without the receipt, without the records, no one really knew what she bought. We knew there was a return. The item itself was not returned. That's fine, the barcode was. There was no dispute that a purchase was made. The argument was that she purchased a used comforter that was infested with bed bugs. That has always been denied in this case, up until the date of trial.
Deceptive.
What's deceptive?
Well, if you say, did you specifically say we're disputing you bought a used, but we do agree you bought a new comforter there?
Until the receipt was secured, we knew she made a purchase, and we knew there was a refund for that purchase. We're talking about years down the road. It was difficult to discern exactly what had been purchased. There were two women who purchased items that day at different registers. Two of the transactions involved cash. One or two of them were debit card. There was some confusion. Admittedly, there was confusion over what was purchased.
The barcode didn't indicate what the item was that was refunded?
She had the barcode, but not the actual item.
But that's my understanding, she was told not to bring the item back to the store.
That is the anecdotal evidence. There's been no, there's nothing in the record to support that, but that is what plaintiff claimed. We're not disputing there was confusion over what date the item was purchased. If we move aside from that, plaintiff still got her day in court.
Well, wait, let's not move aside from that,
Okay.
because we have some questions
Sure.
regarding it. Because I still don't understand. Did Burlington Coat Factory admit that she had made purchases?
Yes. We believe those purchases, however, were February 23rd, not February 11th. We were
So
off
that
by a
was-
couple weeks.
That was in discovery. We
Yes.
agreed that she made purchases.
Yes.
Okay. But you indicated we do not agree that she made a purchase of a used comforter.
That was infested with bed bugs, correct?
But you didn't say we agree that she made a purchase of a comforter that day.
Yes, there was consent that she made a purchase.
I asked of a comforter.
We did not have documentary evidence that was a comforter, but we did not deny that fact.
Wouldn't that be something that would be easy to find from Burlington?
One would assume, Your Honor, that after years go by without a specific date, with the assumption that some of these purchases may have been in cash, with the realization that it was a sister buying some items, plaintiff buying others, there was a great deal of confusion over exactly what was purchased and when it was purchased. But that's what discovery is for. And through the discovery process, we were able to narrow down. It was not February 23rd as we thought, it was actually February 11th. Still on that date, fine, there was a comforter. It was not a used comforter, and there were no bed bugs in it.
Well, and that's where I get to the point of, isn't that a little deceptive? If you say she did purchase a used comforter that had bed bugs in it, as opposed to saying, although plaintiff purchased a new comforter from Burlington Coat Factory, that we deny that she ever purchased a used comforter with bed bugs.
Well, that was the point. Early in discovery, Burlington doesn't sell anything used. So it's not possible for her to have purchased a used comforter.
She was probably just used, that you would think.
I'm sure she was.
And if you buy, I'm not saying this occurred or didn't occur, but if you buy a comforter and it has bed bugs in it, the first thing you're gonna think of is somebody returned that from a home that had bed bugs.
Sure, and as plaintiff, she had the burden to demonstrate that that comforter had bed bugs in it. And that she attempted to do it during the course of discovery. She survived dispositive motion practice. We got to court. There was a jury and panel ready to hear and adjudicate plaintiff's claims. At the trial, plaintiff refused to participate in the proceedings. There was some discussion by plaintiff about what was said, what was not said. In this regard, it's easy. We have a record. There was a very long discussion with Judge Kimbler. Plaintiff was very clear. She intended to prosecute claims on behalf of her daughter. The judge said, hold on, we can't do that. You're not an attorney. Your daughter's still a minor. She's got 18 years. She can bring her own claims, but we're here today to talk about your claims. Judge Kimbler even gave her a day, sent the jury home for the day, gave plaintiff a day to go home, do a little research, think about her case, think about how she was going to present her evidence. Plaintiff came back. She was given the opportunity to make an opening statement. And during that opening statement, and it's in our briefs, she challenged the jurisdiction of the court, claiming that there was a federal question jurisdiction, Judge Kimbler had no authority to hear her case, and she would not proceed. We have a jury that's been paneled, we have a plaintiff who's refusing to make opening statements, defense moved for a directed verdict. The case law in Ohio is very, very clear. A judge has authority to grant a motion for directed verdict at the close of the plaintiff's opening statement when that statement indicates that the party will be unable to sustain its cause of action or defense at trial. That is what happened here.
Counsel, let me ask you this too. When those dispositive motions were filed,
Yes, ma'am.
did Burlington raise the issue of her representing her daughter and saying she's not properly before the court?
No. We never had any indication that this was going to happen. Her daughter's name's not on the complaint. It's just the mother. And I understand there's a pro se issue here, but we understood one plaintiff. And she did talk about her daughter throughout discovery, but never affirmatively raising questions or raising claims on her daughter's behalf.
she allege in the, and obviously we'll be able to look at all the records, but we have not had an opportunity yet. In the complaint itself, did she allege allegations about her daughter being bitten by bed bugs?
I don't know the answer to that, Marva.
Okay, and did she
I know her
ask-
name doesn't show up in there. I'm
In the
not
caption.
sure if she said something about her daughter in the body.
Okay, and when she prays for relief, does she ask for relief for her daughter?
Mhm. The plaintiff was asking in her complaint for a trial by jury. Plaintiff received that trial. There were issues in discovery. I would argue there are always issues in discovery. That is the point of discovery. Let's narrow down the issues. Was the comforter purchased on February 23rd, or was it purchased on February 11th? And frankly, Burlington's argument on dispositive motion below was a statute of limitations argument. They would have happily gone with the February 11th date instead of February 23rd, because it would have put her even further on the statute of limitations.
So in their summary judgment motion, in your summary judgment motion, I should say, Burlington never disputed the fact that a comforter was bought.
No, it was strictly date, the 4-year statute of limitations had run. There are no further questions from the court. I'm taking a seat.
Thank you.
Thank you for your time, members.
You're out of time. But I will tell you both that we will take the matter under advisement. We will look at everything and we will issue a written opinion. And that will be sent to both sides. Thank you.
Thank you.
The next case is Agarwal, Harton versus Agarwal. Both sides ready to proceed?
Yes, Your Honor.
Each side will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes. You just need to alert me as to time you need, and I'll try to say that for you. Also, I would alert you to the fact that there is a monitor up there that also tells you the time. It may be helpful. Okay, you're ready to go. We're ready to hear it.
Thank you so much. Good morning, Your Honors. I am Jessica Bacon from Bevan and Associates, and I represent the appellant Buddy Hartung in this case here today against Dr. Agarwal, Antel, and Hudson Dermatology. This case today is a negligence case.
Before you go any further, did you want to sentence?
Oh, I'm sorry. Let me save 2 minutes. Thank you. This is a negligence case in which a doctor skilled in her field of dermapathology stepped out of her skill set and performed a procedure that she was not skilled in, a cosmetic procedure that resulted in harm to her patient, Betty Hartung. Prior to November 2015, Betty Hartung had treated with Dr. Antel numerous times for many years, and there was never a problem. And what's important about that is that all of her previous procedures that related to cosmetology in any way were pre-mixed, pre-boxed facial chemical peels that required no intervention or mixing or really decision-making by Dr. Antel. The strength of the acid in those peels, Dr. Antel referred to as mild. In November 2015, a new procedure was attempted. It was a new procedure for Betty, and it was a new procedure for Dr. Antel. In her deposition, Dr. Antel told us that she could not recall a situation in the past where she had used a TCA, an acid peel, to treat sunspots on someone's arms. So this was new for everybody. This day, Betty Hartung signed a written consent to have a TCA less than 35% strength used on her arms. But what transpired that day was a 35% TCA being applied to her face, her hands, and her arms in multiple coats. While this application was happening, Betty was screaming in pain. Her screams were so severe that her staff, Dr. Antel's staff, added in the notes that they feared she was having a heart attack. Today, almost 4 years later, Betty still experiences extreme sensitivity, burning, and reddening of her body where this acid was applied in multiple coats. Her injury is not one that is visible all the time, and in fact, one of the ways she deals with it is to keep those areas covered all of the time. But there are multiple sets of photos that were part of the record showing her arms at different times and showing that injury. There were 3 medical professionals involved in this case on the plaintiff's side. The first was Dr. Gregory Klassen, a local dermatologist. Dr. Klassen reviewed the records from this case and provided the initial affidavit of merit that was filed along with the complaint.
Counsel, is that affidavit of merit, can it be attributed to the plaintiff's evidence in the motion for summary judgment?
We didn't, I believe it would probably have to be amended a little bit to be an affidavit that complies with the requirements for summary judgment support. We did not attach the affidavit of merit as an exhibit to summary judgment. So I'm not sure how that would have played out if we had. We used the second doctor's report.
Okay, so that particular doctor was not depoted, correct?
Correct.
Okay,
Which
but
is
parts of his report were part of another doctor's.
correct. That's correct. And his, Dr. Klassen also did an examination of the plaintiff very early on in this case, and he diagnosed her with her injuries from this PO, which were hyperpigmentation and hypersensitivity as a result of this application. So Dr. Klassen's medical opinions as they relate to proximate cause and even to standard of care in this case were disclosed to the defense very early on. It was part of our written discovery. We gave that office note, and Dr. Klassen was, he's local, he's 10 minutes from my office. And he was never deposed. He was never requested to depose him. Plaintiff then was in a situation where Dr. Klassen had mentioned to me that he was looking to retire soon. He had asked me about a timeline for this case, and I can never really give an accurate one. So plaintiff sought out another expert, Dr. Ehrenreich in New Jersey, to review these records and asked if he could provide support. He reviewed the testimony, the deposition transcripts, of which there were several at that time, and he reviewed the records. He reviewed Dr. Antel's notes, Dr. Klassen's note, and provided a detailed report on the standard of care violation after his review. He was deposed, and the subject of his deposition is actually the subject of the trial court order that we're here on today. Dr. Ehrenreich, in his report and in his deposition, he recognized that there was a glaring dispute over the facts in this case. The facts of what transpired as far as actions and conversations in that doctor's office. He noted that there was a dispute of facts between the plaintiff, between the defendant, and between the defendant's assistants who were deposed. He properly concluded that he cannot weigh the credibility of the parties. He cannot say, this person told the truth, this person did not. That was not his job. So what he said was, if plaintiff's testimony is accurate, if the jury determines plaintiff to be the one correctly reflecting what happened that day, then yes, Dr. Antel violated the standard of care. Dr. Ehrenreich's purpose was standard of care, and he fulfilled that. It was made a big deal in dispositive motions, some sections cherry-picked from Dr. Ehrenreich's deposition. And there was a question asked of him saying, based on the photos, you cannot say she suffered an injury from this procedure. And his response was, based on the photos, no. The patient has claimed an injury. I cannot say she doesn't have an injury. She says she has sensitive skin. She says she reacts to sunlight. I can't tell you she doesn't have an injury. All I can tell you is from the photos, I don't see an injury. And that was accurate. Photos that were taken on the day of her deposition inside my office, not in the sun, not in the heat. You could look at her and you don't see an injury. That's accurate. But Dr. Ehrenreich recognized that she was claiming an injury. He did see Dr. Klassen's report, which diagnosed the injury, and he made the conclusion that if what happened is what plaintiff says happened, then there's a problem here. There's a standard of care violation. The third medical professional that I believe supports plaintiff's case is Dr. Antal herself. She was identified as an expert by the defense, and Dr. Antal testified over 2 depositions that she used an acid peel 15% stronger than she had originally planned to use, that she told Betty she was going to use, than she had used in the past, and 15% stronger than she ordered and that she received. And the reason she used this stronger peel was because on the day that Betty arrived for her appointment, Dr. Antal couldn't find the bottle. It had been received, it was in her office because it was turned over months after her deposition as found. But on that day, she couldn't find the bottle. So she used what she had, which was 15% stronger. She had never used it on sunspots on arms before, but she used it, and she used it on multiple coats. Dr. Antal also admitted that Betty did have what she referred to as an extreme reaction. You know, you go for a chemical peel, the thought is you're going to burn your skin's gonna burn. But this reaction that Betty had was testified to by her doctor and the assistants that it was extreme. They had not been in a situation like this before in all the years of practice. Dr. Antal also admitted that she added or edited Ms. Hartung's records later on. And that goes to another issue in this case, but definitely her credibility is one that should be determined by a jury. In this case, the trial court accepted Dr. Antal's version of the facts as true, and really they were highly contested. The law cited in my brief is that this court recently created this year in Pearson versus Alpha Phi Alpha Homes. And in that case, this court reversed the trial court's decision as it abused its power when it weighed the testimony of experts. And that's really what I believe was happening here. And when we're talking about the testimony of experts, that's everyone. That's Dr. Antal as well, because she was identified as an expert in this case. And her credibility being weighed should not be weighed as a fact witness, should be weighed as expert testimony. She was offered as an expert and gave testimony clearly above that of a lay witness.
Does it make any difference, counsel, in terms of weighing testimony at the summary judgment phase, whether it's a fact witness or an expert witness?
No, it shouldn't be weighed at all. Thank you. This court, the Ninth District, also ruled in 2017 in Nation Star Mortgage versus Wiseman that a trial court does not have the liberty to choose among inferences in the context of summary judgment, and competing inferences or questions of credibility to be resolved in the non-moving party's favor. In this case, the defendant picked small sections of plaintiff's expert's deposition as its entire basis for saying plaintiff cannot prove negligence. It was error for the trial court to agree. The law requires the trial court to review the entire transcript, and that did not happen in this case. And I cited the 3rd and 7th District cases that relate to that issue. At the end of this, maybe Dr. Ehrenreich doesn't hold up on cross by a skilled attorney as Mr. Rossi. Maybe Dr. Antal doesn't hold up on cross by myself. Maybe the jury doesn't believe Betty Hartung when she comes into court and she looks great, that she was injured. But all of that is not to be determined by the trial court. Plaintiff has put forth testimony on negligence and standard of care, and any analysis of that testimony by the trial court is reversible error, and we ask that you reverse.
I do. Counsel, taking what you say is true, and let's do the reverse. Let's say all facts were found in favor of your client. Is the court and your opponent's argument basically that that wouldn't matter? Because when you have that negligence, one of the elements, final element you need is the damages, and you didn't need that. So I can take everything your client said as true, just discount everything else, and the argument is you still didn't meet damages.
And I would say that we did meet the damages through the office notes of Dr. Klassen, through the photos, and through the plaintiff's testimony.
Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, my name is Carol Tran, and along with my co-counsel, Attorney Rossi, we have the privilege of representing Dr. Antal and Hudson Dermatology today. And I want to begin my argument with a point that was raised by Your Honor, Judge Callahan, that I believe is the crux of this argument. It's the fact that even if we were to interpret any disputes of facts in favor of the plaintiff, we can't ignore what is said by Dr. Ehrenreich. And this portion of his deposition testimony, I think, is very black and white, and this is the problem that plaintiff has. And it's located on page 68 to 69 of Dr. Ehrenreich's testimony. This is the question and answer. Question: you cannot state that this patient suffered an injury as a result of the care and treatment provided by Dr. Antal in this case. True? Answer: correct. Question: you cannot state to a reasonable degree of medical probability that any negligent act by Dr. Antal caused this patient injury. True? Answer: true. So even if we view all the evidence in a light most favorable to the plaintiff, the fact of the matter is they don't have the necessary expert testimony to support their claims, which is required by the Ohio Supreme Court case of Bruni versus Tatsumi. That is the ultimate issue before this court. Whether this court will overturn the trial court's grant of summary judgment in favor of Dr. Antal when she does not have the requisite expert testimony to support her medical claims. The three major claims that she has before this court are medical negligence, lack of informed consent, and punitive damages. There's been a lot of discussion about whether the trial court weighed the credibility of the expert. And if your honors take a look at the orders that were set forth by Judge McCarty on January 9, 2019 and February 28, 2019, there's simply nothing in those orders to indicate that the credibility of the expert was weighed. There's no discussion about Dr. Ehrenreich's credentials or lack thereof. There's no discussion of whether he's trustworthy or not. There's no discussion or suggestion that the trial court simply failed to read the entire deposition transcript. The mere fact that they have cited certain portions from the deposition transcript is not an indication that the entire deposition transcript was not read. But the fact is, credibility wasn't the issue before the trial court. The issue was whether Dr. Ehrenreich was able to provide testimony in support of those four elements under Bruni. And Bruni requires that plaintiff, through preponderance of the evidence, demonstrate the duty of care, that Dr. Antal breached that duty of care, and that there was a proximate cause of those injuries. So we have to focus on the expert testimony that was set forth by the plaintiff. And the only expert that they have in this case is Dr. Ehrenreich. I want to make that very clear. There's been some discussion about Dr. Clausen. Dr. Clausen was never identified as an expert below. He never produced an expert report. The only thing that he provided was an affidavit of merit. Because he was not identified as an expert witness or provided a report, he's not considered an expert for the plaintiff. His testimony was not taken as a result, and anything that he might have said was not entered into evidence and was not before the trial court to consider at the summary judgment stage. The only expert they had identified on their behalf was Dr. Ehrenreich.
What was the doctor's notes before the trial court to be considered by virtue of being part of the expert's notes or deposition?
That was part of the evidence that may have been reviewed by Dr. Ehrenreich as part of his file. His file, however, was not submitted to the court for review at the summary judgment stage, is my understanding. We did not have the underlying expert file of Dr. Ehrenreich before the court. That was not submitted by the defendant. So the only expert that they have on their behalf is Dr. Ehrenreich. And we can split the medical treatment on November 20, 2015 to essentially two different body parts. We have first the application of the TCA peel to her face, and then we have the application to both of her arms on the right and left side. And Dr. Ehrenreich is very clear in his deposition that he felt Dr. Antel actually complied with the standard of care with respect to the face. So the face is not an issue. Dr. Ehrenreich concedes that point. So there is no expert testimony to support their claim of injury with respect to Betty Hartone's face. So the only thing that we're left with then are the arms. And I want to make it very clear what his criticism is. His sole criticism against Dr. Antal is if she applied 35% TCA twice to a fully frosted area. That's his only criticism. And the reason I point that out is because there was some question as to whether this was a premixed material or something that had to be mixed up by a pharmacy. Dr. Ehrenreich doesn't have an issue with the composition of the mix, who it was mixed by. He doesn't have an issue with the strength of the TCA peel, whether it be 20%, 35%, 50%. He doesn't have an issue if 2 coats of the 35% TCA peel were applied to an area that was not fully frosted. So his criticism is extremely limited. And at all points, his criticism is always prefaced with the word if. And that's a hypothetical answer. Every time he was asked whether Dr. Antel had violated the standard of care, you can only provide an if statement in response. And that's a problem because that doesn't meet the level that is required of a medical expert. A medical expert has to provide an opinion to a reasonable degree of medical probability to get above that 50% mark. Providing speculative statements, that's something that anyone can do in court. For Dr. Ehrenreich to support their prima facie claim of medical negligence, he has to state to a reasonable degree of medical probability that Dr. Antel violated the standard of care. And if your honors take a look at the deposition transcript, at no point is he able to do that. But even setting that aside, there's still the issue, like I had talked about before, proximate cause and injury. Those are 2 essential elements of a medical negligence claim. And like I read that passage before, he cannot state that Dr. Antel proximately caused any injury in this case. Face, arms, through any means. He cannot state that. And that's perhaps not surprising because Mrs. Hartong did have a good outcome. We had an opportunity to depose her back in April, and she said herself that on both arms, the brown spots that she very much disliked, they were reduced by half. Her face, also the brown spots that she didn't like, they were reduced. Both her husband and Dr. Ehrenreich said there's no scarring, there's no discoloration. She has healed. So there is no injury in this claim, in this case, and that, I believe that is the basis for Dr. Ehrenreich's testimony and inability to provide any testimony with respect to those elements. 2 other issues I want to briefly touch upon that were not covered before is this lack of informed consent and punitive damages. One thing that I want to make sure that this court is clear on is that lack of informed consent is basically a more specific form of medical negligence. According to the Ohio Supreme Court case of White versus Leinbach, which was issued in 2011, you need medical expert testimony in support of a claim of informed consent. It has the same elements as a medical negligence. duty is to provide a patient with the material risk and danger of the procedure. The breach is if you don't provide that disclosure, you still need proximate cause and injury. And for the same reasons that I talked about before, we don't have the proximate cause element supported by any expert. We don't have injury supported by any expert. In fact, Dr. Aaron Wright said himself during his deposition, he's not going to provide an opinion on informed consent. That's not what he was asked to look at, and that's not what he was going to testify to at any point during this case, in a report or at trial. Finally, there's been some discussion through the briefing regarding the issue of punitive damages. A couple of things that I would like to leave the court with on that issue is, first of all, the last time that Dr. Antel went to her note was almost a month before Mrs. Hartung ever picked up the phone and asked for her medical records from Dr. Antel. There's simply no indication that she did anything to her note to avoid liability or lessen her liability. Because the last time stamp that we have on the note is almost a month before that phone call happened. And everyone, even Mrs. Hartung, agrees that when she called up Dr. Antel's office, she said, I would like my medical records for tax purposes. She never told Dr. Antel, I retain an attorney, I plan on filing a lawsuit. That's not what she said. She said, I misrepresented to Dr. Antel that I needed them for tax purposes.
Counsel, let me play devil's advocate here for a minute. Would the doctor necessarily have had to know that there was going to be some forthcoming negligence suit, or even have an inkling? Should she have been so inclined to go through her medical notes and say, ooh, I don't like the way that one sounds, let me switch it? I mean, does one have to be related to the other?
According to Moskowitz, the Ohio Supreme Court case that discusses punitive damages, one of the essential prongs is to intentionally alter or destroy evidence in reaction or to avoid litigation. So there has to be some knowledge that there might be litigation coming forth. So
How about her screaming in the examining room? Might that be some indication that something could come in the future?
that possibly could be an indication, but I would disagree with those facts. Neither Mrs. Hartung nor Dr. Antel discussed this screaming. They talk about her sitting up, breathing heavily throughout the procedure. Both are very forthcoming that happened. So in terms of screaming, I'm not sure where that appears in the record.
But they did put in the medical records that they thought she may be experiencing a heart attack.
Yes, they did. And to remind the court, this is a chemical peel, so essentially it is a controlled burn that's being applied to one's face and one's arms. It is the whole point, as Dr. Ehrenreich says, of a TCA peel is to cause chemical injury in order to take off that outer layer of skin to reveal the newer skin underneath. So there is going to be some discomfort. And Dr. Antel describes that as something that would be like a severe sunburn. But the other issue with punitive damages is that it's also a derivative claim. So if you don't have a claim for medical negligence, if you don't have a claim for lack of informed consent, you can't have a claim for punitive damages.
I'm still having a little bit of confusion on the lack of consent. So you're saying it was lack of consent that needed a expert's testimony because of what was not related to the patient.
So
Because information was not, complete information was not given.
if I'm understanding your question correctly, yes, according to the Supreme Court, expert testimony is required to support a claim of lack of informed consent, if that's what I'm hearing.
Yes, and then, but didn't she also allege just almost like a battery that she had not given consent at all for her face?
And I'm glad that issue is being brought up because battery was never alleged in the complaint.
But did she have allegations that said she never gave consent for her face to be chemically peeled?
So if your honors take a look at count 3 of plaintiff's complaint, it's captioned as informed consent. And the way it sets forth the elements, it mirrors the elements of a lack of informed consent. And I think the confusion comes with through the briefing that I'm gleaning is that she is now attempting at the appellate level perhaps to now assert a claim for battery, to which consent would be an affirmative defense that defense counsel could possibly assert in relation or in defense to a consent claim, but that's not the claim we have before the court.
Okay,
It's lack of informed-
so, and I'm sorry, I'm interrupting you only because I know we're almost out of time. So you're saying at no time during the summary judgment proceedings or discovery or anything that she alleged that the doctor put the chemical peel in her face without her consent?
I think those allegations have been made by plaintiff's counsel through the trial court proceedings, that there wasn't consent for her face.
And you
But
would need expert testimony on that.
I would disagree with that for lack of informed consent because.
Well,
in
we're
order-
not talking about no consent.
I'm not sure I'm.
Well, you can have informed consent if you're given all the information and you say, go ahead and do it, okay? But if somebody just starts putting something on your face and you haven't consented to that, then it's not a lack of informed consent, it's just a lack of consent, period.
I understand what your Honor is saying, but the only issue that was considered by the trial court, the only claim that was before the court was one for lack of informed consent, and that is something that expert testimony is required by the Ohio Supreme Court.
Okay,
They were not considering that.
Thank you very much, I put you over time, sorry about that.
Thank you. So we request that the court affirm the trial court's judgment. Thank you.
And you have, as the monitor reflects, 2 minutes and 4 seconds.
Okay, Your Honors, unless you have any questions, I believe that I've said everything that I wanted to convey to the court and would forego the rest of my time.
Okay, well, thank you very much.
Thank you.
And the court will take the matter under advisement. We'll issue a written opinion that will be sent to both sides. And you also can look on our website, the Supreme Court website, to get really anxious and may get it just maybe a hair quick. All right, thank you very much.
Thank you.
Thank you all.
Thank you, Your
Have a
Honors.
good day.